Hello friends, this is PP and welcome to another impromptu video on this channel, that is Law for All. In this video we're going to be talking about the Registration of Births and Deaths Act 1969. Now essentially I want to talk about the formalities that are to be followed by any person in the event of the birth of a child or the death of a person. Now the Registration of Births and Deaths Act bestows upon certain responsibilities and obligations upon certain individuals to report a birth or a death of a person to a respective authority for the purpose of registration of records of births and deaths in the country. Now I have the BER Act, that is the Registration of Births and Deaths Act 1969, open here as you can see on your screens, and I'm going to be scrolling through the act and trying to sort of give an explanation as regards various sections, and I will essentially be focusing on, as I've pointed out previously, the formalities that are to be followed in the event of a birth or death of a child, and the responsibilities that are casted upon various individuals under the Act. Now, to begin with, the Act has established various registrars, that is, authorities under the Act, being a chief registrar and many other registrars. The first is the Registrar General of India. That is, there have to be a registrar who will be at the center. That is, he'll be the Registrar General of India, and there will be various other subordinate registrars under him. That is the Chief Registrar and other subordinate registrars. Now, Chief Registrar will be one registrar which will be there, which will be appointed for the entire state, and there will be a subordinate registrar functioning under him. That is, the state government will have the power to appoint as many registrars as may be required. Now, registrars are generally appointed in the municipalities or the village panchayats, as the case may be. And in the case of village panchayat, as in the state of Goa, it is generally the secretary of the village panchayat, and as in the case of a municipality, it is generally the chief officer of the municipality who is the registrar appointed under the Births and Deaths Act. Of course, he will also have the powers to appoint various other orderlies under him to perform the various formalities for the purpose of registration of births and deaths. There is also a district registrar that is appointed, that is a registrar subordinate to the state registrar for the purpose for an individual district, who shall discharge the functions that have been bestowed upon him. He shall essentially control the subordinate registrars under him. Now, mostly a separate registrar altogether is not appointed. Generally functioning, an officer of that government is generally bestowed upon with additional responsibilities under this act. Now, registrar, as we can read, the state government may appoint a registrar for each local area comprising within the area of jurisdiction of a municipality, panchayat, or any other local authority, any other area of a combination of two or more of them. So there were municipality, panchayat, and any other local area which governs that particular area will have an officer who will be appointed as the registrar. Is generally given the additional charge of being a registrar. Now, let us get into the persons required to register births and deaths. Now, it shall be the duty of the person specified below to give or cause to be given either orally or in writing, according to the best of their knowledge and belief, within such time as may be prescribed, information to the registrar of several particulars required to be entered in the forms prescribed by the state government under subsection 1 of section 16. Now, in respect of births and deaths in a house, whether residential or non-residential, it will have to be the head of the family, or if in the absence of the head of the family, the nearest relative of the nearest head of family present in the house, and in the absence of such person, the oldest adult male person present therein. So therefore, a female adult female cannot is not given the powers or the authority to report births or deaths, but it is generally the adult male person that is given the authority to report. Now, in respect of births and deaths in a hospital, healthcare center, maternity or nursing home, or other like institution, the medical officer in charge of or any other person authorized by him on his behalf. So the medical officer, that is essentially the doctor. In respect of births and deaths in a jail, the jailer. In respect of births and deaths in hostel, dharmashala, boarding house, etc., the person in charge. In respect of any newborn child or dead body found deserted in a place, the headman or the corresponding officer of the village, as the case may be, or the officer in charge of the local police station elsewhere. So if it is found within the jurisdiction of the village panchayat, then it will have to be the sarpanch, or because he is the head of that area, in terms of administration, and otherwise the police in charge of a police station which exercises jurisdiction of that area. So that person will have to give information. That is, these people are duty bound to give information to the registrar as regards a death or a birth that takes place in their jurisdiction, and if not, then there are penalties prescribed. So therefore they can be penalized if they derelict in discharging their duties. Now, special provisions regarding births and deaths in plantations. So this section, although it has been specially created, but I believe this concept is a little redundant in the present times. So I shall not go into it. If you want, then you can pause the video and you can read through it. Now, duty of certain persons to notify births and deaths and certify the cause of death. Now, this section essentially talks about the duties of persons to notify. That is, if in case a child is born in a hospital, it is the duty of the doctor who has delivered the child, or the head doctor, as the case may be, to notify the birth of that child to the respective registrar or the authority established, which is generally the registrar, depending upon in whose jurisdiction the hospital is located. Now, for the purposes of this act, when the child is born, generally the name of the child is not pre-decided. So therefore, it is the duty of the doctor to inform the registrar as regards the birth of that person, the birth of that child, and all the other requisite details, birthmarks and weight and etc. So therefore, a formal entry into the records of the registrar is made, and then subsequently there is a prescribed time limit, within which the name of the child has to be communicated to the registrar, and then accordingly the name is reflected in the birth certificate of the child. So that is essentially the process that is followed. As in the case of a death, if a person expires, then what is necessary is that again the registrar has to be informed, and the registrar then creates a record of the death of that specific person. So therefore, essentially in most of the states, what is necessary is that if a person expires, then a doctor's certificate is necessary. That is, the doctor will have to we will have to physically check the body of the person, the deceased person, and then deduce as to the cause of death and give a certificate to the effect that the person died of natural causes. So when that certificate is given, only then will the registrar register the death. If not, then the authorities will take over, and then the authorities will effect the death will effect the entry of the death of that person, because a person can also die of unnatural causes. That is, a person can be murdered or can meet with an accident. So therefore, in such cases, the doctor is required to give a certificate to the effect as to how the person died. So if the person died of natural causes, then the death can be registered and generally no inquiry is held. But if the person dies of unnatural causes, then prosecution, investigation would have to be held, and the person who led to the death of that person will have to be tried. So for the purpose of investigation and for the purpose of collection of evidence, a doctor is required to certify the death of a person before the person can be cremated. So therefore, in many of the states, it is mandatory that a doctor's certificate is required as to how the person died, and a medical practitioner again is required to forthwith issue, without charging any fee to that person required under the act, give any information concerning the death or a certificate in the prescribed form stating to the best of his knowledge and belief the cause of death, and the certificate shall be received and delivered by such person to the registrar at the time of giving information concerning the death as required by this act. So the certificate will also have to be proved, and the necessary information will have to be given to the registrar for the purpose of registering the death. Now, the registrar is also required to maintain registers in which all the details are required to be stated, and whoever is informing the registrar will also have to sign. That is generally because somebody has to take the accountability of the information given, because there is also a penalty prescribed for giving false information as regards the birth or death of a person. Now, there is provisions also for delayed registration of a person. That is, if any birth or death of which information is given to the registrar after the expiry of 50-day period thereof, but within 30 days of its occurrence, shall be registered on payment of such late fees as may be prescribed. So any birth or death of which delayed information is given to the registrar after 30 days, but within 1 year of its occurrence, shall be registered only with the written permission of the prescribed authority, and on payment of prescribed fees and production of an affidavit made before a notary public or any other officer authorized in behalf of the state government. And if the death or birth of a person is not registered within a period of 1 year from the date of its occurrence, then it will have to be tried. Then an order will have to be given by the magistrate, and then accordingly the registrar will register it. So therefore, the if the death or the birth of a person, birth of many people rather, that is generally the circumstance. If your birth has not been registered, then you have to go to before the magistrate, move an application before the magistrate, and then the magistrate will hold an inquiry and will see whether if the person has actually is actually born on the date on which the person professes to have been born on, and then accordingly an order is drawn and the registrar is directed to register the birth. So that is essentially the procedure that is followed. So section 13 subclause 3 provides for registration of births which are not registered within a period of 1 year from the date of its occurrence. Now, as I already previously stated, the registration, this section 14 talks about the registration of a name of a child. That is, you can also subsequently register the name of the child. Now, correction and cancellation of entries in the register of births and deaths is also been provided for. So there is, if false information is given, fraudulent information is given, or if the name is reflected incorrectly, then the same can be corrected. Of course, there is a long lengthy procedure that will have to be followed. In some cases, names on a small advertisement on the newspaper is also required to be given if in case there is some correction of name in the birth or death records. But generally that is the procedure that is followed. So summing up, if in case a child is born in the hospital, it is the duty or the responsibility of the doctor to give information. If in case a person expires at his residence or her residence, then a certificate will have to be obtained from the doctor. A doctor will have to be summoned, a medical practitioner will have to be summoned. He will have to give a certificate to the effect that the person has died of natural causes or whatever causes as the case may be, and a certificate will have to be given. That certificate is to be produced before the registrar, who then will register the death of that person. So these are the procedures that are essentially required to be followed under the act. And if in case the person who is responsible for intimating the death or birth of a person does not discharge the duties, then that punishment is also prescribed. That is, they will have to pay a fine of ₹50. Of course, this act was enacted way back when, so therefore the fine is only limited to an amount of ₹50. But of course, now since the advent of since the society has developed so much, there is some amendment is necessary for the purpose of incrementing the said fine under the act. So well, that is all about it in this present video. I have left some useful links in the description section of this video if you'd like to learn more on various topics under the Indian law. So kindly do check that out if you're interested. Like this video if you found this useful, share this video and subscribe to this channel for more such content. Until then, this is PP saying bye.